Hello friends, welcome to EPG Pathshala. Today I am going to tell you about the disposal of hazardous waste and other waste Transboundary Movement Rules 2016. After hearing this lecture, you will be able to understand that what are the rules which govern the transboundary movement of hazardous and other waste. You will be able to understand the rules which govern the import and export of hazardous and other waste, and you will be able to know that what responsibility has been given to different entities regarding disposal of hazardous and other waste. Now first of all, let us start with the introduction. Hazardous and other waste. A lot of hazardous and other waste is being generated by the industries. Now one of the main problem regarding this waste is how to dispose it of. So the disposal is the main issue, and if the rules are not governed properly and the disposal is in an improper manner, then there is problem of soil pollution. This pollution can also enter water and can lead to water pollution. This further leads to health related problems. Another issue which is related to hazardous and other waste is the way in which the factory workers deal with it, because the factories in which this waste is generated, there the workers are exposed to a very high risk. So basically the government wanted to address this issue, and it was in this regard that Hazardous and Other Waste Management and Transboundary Movement Rules 2016 was passed by the government. Now before understanding the rules, let me give you a brief overview of the rules. In total there are 24 rules and they are divided into 6 chapters. Chapter 1 is titled as Preliminary and contains Rule 1 to 3. Rule 1 talks about the short title and commencement. Rule 2 talks about the applicability of these rules, and Rule 3 enlists some of the important definitions which are required to be understood in order to interpret these rules. Moving forward, Chapter 2 is titled as Procedure for Management of Hazardous and Other Waste. It contains Rule 4 to Rule 10. Rule 4 and 5 talks about the responsibility of the occupier and the state government for management of hazardous waste and other waste respectively. Rule 6 and 7 talk about the procedure for grant of authorization for managing hazardous and other waste and the power of the State Pollution Control Board to suspend or cancel this authorization in case of non-compliance. Rule 8 talks about storage of hazardous and other waste. Rule 9 talks about utilization of hazardous and other waste, and Rule 10 talks and empowers the Ministry of Environment, Forest and Climate Change as well as the Central Pollution Control Board to issue guidelines or standard operating procedures for environmentally sound management of hazardous and other waste from time to time. Chapter 3 is titled as Import and Export of Hazardous and Other Waste and contains Rule 11 to Rule 15. These rules basically govern the import and export of hazardous and other waste. Rule 11 envisages that Ministry of Environment, Forest and Climate Change is the nodal agency to deal with the transboundary movement of hazardous and other waste. Rule 12 talks about the strategy that is to be followed in India as far as import and export of hazardous and other waste is concerned. It enlists rules and conditions subject to which import and export of hazardous and other waste can be undertaken. Rule 13 and 14 talks about the procedure that is to be followed for import and export of hazardous and other waste respectively. Rule 15 talks about the conditions which shall render the import and export of hazardous and other waste illegal. Moving forward, Chapter 4 is titled as Treatment, Storage and Disposal Facility for Hazardous and Other Waste. It contains Rule 16. This rule holds the state government, operator of a facility, occupier or association of occupiers responsible for identifying sites for establishing the facility for treatment, storage and disposal of hazardous and other waste in the state. Next chapter, chapter 5, is titled as Packaging, Labeling and Transport of Hazardous and Other Waste. This chapter contains Rule 17 to Rule 19. Rule 17 describes the manner of packing and labeling hazardous and other wastes. Rule 18 and Rule 19 tells the procedure to be followed while transporting the hazardous and other wastes. The last chapter of the rule is titled as Miscellaneous and is numbered as chapter 6 and contains Rule 20 to 24. Rule 20 and 22 talks about the responsibility of the occupier handling hazardous or other waste and operator of disposal facility to maintain records and returns and their duty to intimate the State Pollution Control Board in case of accident. Rule 23 talks about the liability of the occupier, importer or exporter and operator of a disposal facility to pay penalty in case of damage to environment or third party due to improper handling and management of hazardous and other waste. Rule 21 talks about the responsibilities of the authorities to perform the duties as specified. Rule 24 provides for appeal in case a person is aggrieved by the order of suspension or cancellation or refusal of authorization or its renewal passed by the State Pollution Control Board. Now, once the overview of the rules is clear, let us move to the applicability of the rules. As discussed earlier, Rule 2 specifically talks about the applicability of the rules. Now, please remember that these rules are applicable to two categories. One is to hazardous waste and second is to other waste. Now, let us understand what is hazardous waste. According to Rule 3, Sub-Rule 17, hazardous waste means any waste which by reason of characteristics such as physical, chemical, biological, reactive, toxic, flammable, explosive or corrosive causes danger to health or environment. It also includes the waste generated during the manufacturing processes of the commercial products such as industries involved in petroleum refining, production of pharmaceuticals, petroleum, paint, aluminium, electronic products, etc. For more details into this, you can see Schedule 1 that is attached to the rules, which gives a detailed list of processes through which hazardous waste is generated. Now, hazardous waste also contain waste having a concentration limit of a constituent more than that specified in Schedule 2 or exhibit characteristics such as flammability or ignitability or corrosivity or reactivity, etc. due to the presence of any hazardous constituents. For example, if a waste has concentration of arsenic more than 5.0 mg or mercury more than 0.2 mg per liter, then it will be termed as hazardous. For more details into this, you can see Schedule 2 that is attached to the rules, which gives a detailed list of waste constituents with concentration limits. In case of import or export, waste such as those specified in Part A and Part C of Schedule 3 is considered as hazardous waste. Now, moving on to the second category, that is other waste. Other waste means waste specified in Part B and Part D of Schedule 3 for import or export and includes all such waste that is generated indigenously within the country. It is important to remember that these rules are not applicable to first, wastewater and exhaust gases as are covered under the provisions and Rules of Water Act and the Air Prevention and Control of Pollution Act. Secondly, the rules are not applicable to the waste arising out of the operation from ships beyond 5 kilometers of the relevant baseline as covered under the provisions and rules of the Merchant Shipping Act. The rules are also not applicable to radioactive waste that are covered under the provisions and rules of Atomic Energy Act. The rules are also not applicable to biomedical waste that is covered under the Biomedical Waste Management and Handling Rules 1998 and waste covered under the Municipal Solid Waste Management and Handling Rules. Now, once it is clear that what is meant by hazardous waste and other waste, let us move on to see that who is responsible for managing hazardous waste and other waste. Now, it is important to remember that industries are generating a lot of hazardous and other waste while processing, manufacturing, etc. Disposal of this hazardous waste is a cumbersome procedure. So, the rules entrust that the responsibility for the management of such hazardous and other waste is on the occupier as well as the state government. Now, let us understand what is the responsibility of the occupier. Rule 4, Sub-Rule 2 casts a responsibility on the occupier of this place for safe and environmentally sound management of hazardous and other waste. The occupier shall follow a number of steps for the management of hazardous and other waste. These steps are prevention, minimization, reuse, recycling, recovery, co-processing, and safe disposal. It is important to note that these steps are to be followed in a hierarchical manner. That is, the occupier should in the first place try preventing the generation of hazardous and other waste or try to minimize it. Then effort should be made to reuse or recycle this hazardous and other waste. Thereafter, effort should also be made for recovery of specific material from this hazardous and other waste. The occupier should try to co-process, that is, he should try to generate energy out of this hazardous and other waste so that the use of conventional fuels is reduced. And the last is safe disposal. The rules entrust the occupier that he should take all steps that are necessary to contain contaminants and prevent accidents and limit their consequences on human beings and environment. He should also provide persons working in the site with appropriate training, equipment, and the information to ensure their safety. Now, once we have understood the responsibility of the occupier, let us see what is the responsibility of the state government. Now, the state government has to set up or allot industrial space or sheds for recycling, pre-processing, and other utilization of hazardous or other waste for environmentally sound management of hazardous and other waste. The Department of Labor in the state has been entrusted with the responsibility to first, recognize and register the workers involved in recycling, pre-processing and other utilization activities. Second, form groups of workers to facilitate setting up such facilities. Third, undertake industrial skill development activities. And fourth, ensure safety and health of workers. Safe disposal of hazardous and other waste. Scientific disposal of hazardous and other waste through proper collection, storage, packaging, transportation and treatment in an environmentally sound manner minimizes the adverse impact of such waste on human health and environment. The rule envisages two types of mechanisms for safe disposal of hazardous and other waste. These two mechanisms are authorized actual user and authorized disposal facility. Now let us see what is authorized actual user. Actual user means an occupier who procures and processes hazardous and other waste for reuse, recycling, recovery, pre-processing, utilization, including co-processing. Authorized disposal facility means when the occupier sends hazardous and other waste to the disposal facility, he shall give specific information as may be needed for safe storage and disposal. The hazardous and other waste must be transported in accordance with these rules. Authorization to deal with hazardous and other waste. The rules provide that authorization is required for generation or collection or storage or transport or reception or recycling or reuse or recovery or utilization or treatment of disposal of hazardous and other waste. The application for obtaining this authorization is to be made in Form 1 to the State Pollution Control Board. The board will then conduct an inquiry, and after being satisfied that the applicant possesses technical capabilities and the equipment which is required for complying with the standard operating procedures or other guidelines as specified by the Central Pollution Control Board, grant authorization. This authorization is to be granted within a period of 120 days, and the authorization will be granted in Form 2. The State Pollution Control Board may, after giving reasonable opportunity to the applicant to be heard, may also refuse to grant authorization. However, it has to record the reasons for the same. The board can also impose conditions on the applicant while giving authorization. The authorization shall remain valid for a period of 5 years, and the application for renewal of authorization may be made 3 months before the expiry of such authorization. The applicant who has been authorized has to maintain records of hazardous and other waste in a passbook that is to be issued by the State Pollution Control Board. The board is also empowered to suspend or cancel the authorization if the holder of the authorization has failed to comply with the conditions or has failed to comply with any rule or any provision of the Environment Protection Act 1986 under which these rules have been framed. However, before suspension or cancellation of authorization, the applicant should be heard, and the reasons for suspension or cancellation must be recorded in writing. The authorization can be suspended or cancelled for such period as is necessary in public interest. However, no authorization is required if a person was authorized under the Hazardous Waste Management, Handling and Transboundary Movement Rules 2008 till the period of expiry of authorization under those rules. Now let us see how hazardous and other waste can be utilized. The utilization of hazardous and other waste as a resource or after pre-processing, either for co-processing or for any other use, including within the premises of the generator, shall be carried out only after obtaining authorization from the State Pollution Control Board. The utilization is to be made on the basis of standard operating procedures or guidelines as are provided by the Central Pollution Control Board. In cases where standard operating procedures or guidelines are not available for specific utilization, the approval has to be sought from Central Pollution Control Board, which shall grant the approval on the basis of trial runs. Storage of hazardous and other waste. The occupiers of facilities may store the hazardous and other waste. However, this period shall not exceed 90 days, and they have to maintain a record of the sale, transfer, storage, recycling, recovery, pre-processing, co-processing and utilization of such waste. These records are to be made available whenever called for inspection. However, this period of 90 days can be extended by the State Pollution Control Board in cases where First, occupiers do not have any access to any treatment, storage, disposal facility in the concerned state, or second, where the waste needs to be specifically stored for development of a process for its recycling, recovery, pre-processing, co-processing or utilization. The period can be extended to 180 days in case of small generators, actual users and disposal facility operators, or in any other case on justifiable grounds. Now let us see how import and export of hazardous and other waste is regulated. The rules prohibit import of hazardous and other waste specified in Schedule 6. The rules also prohibit import of hazardous and other wastes for disposal. However, the import is permitted for recycling, recovery, reuse and utilization, including co-processing. The Ministry of Environment, Forest and Climate Change is the nodal agency to deal with the transboundary movement of hazardous and other wastes. The waste that can be imported are specified in Schedule 3 attached to the rules. The items mentioned in Part A of this schedule can be imported with the prior informed consent of the exporting country and permission of the Ministry of Environment, Forest and Climate Change. The items mentioned in Part B of Schedule 3 can be imported by the actual users with the permission of the Ministry of Environment, Forest and Climate Change. The permission can be obtained by applying in Form 5 to the Ministry. The Ministry shall examine the application and shall make any comments and observations on that and may grant the permission for import within a period of 60 days. However, this permission may be granted with the condition that the importer has environmentally sound facilities, adequate arrangement for treatment and disposal of waste generated, and a valid authorization and consent from the State Pollution Control Board, plus prior informed consent from the exporting country in case of Part A of Schedule 3 wastes. The items mentioned in Part 3 of the schedule can be imported without permission, subject to furnishing of information to custom authorities. This information is to be furnished in Form 6 accompanied by requisite documents. Moving on to export, the export of hazardous and other waste from India listed in Part A, Part B, Part C of Schedule 3 and Schedule 6 shall be with the permission of Ministry of Environment, Forest and Climate Change. The application for the same is to be filed with the Ministry in Form 5. The Ministry may impose conditions for export. The exporter has to maintain records of the same and has to ensure that the shipment is accompanied with movement document as specified in Form 6. Illegal traffic. It is important to note that the import and export of hazardous or other wastes shall be deemed illegal if it is done without the permission of central government in accordance with these rules, or the permission has been obtained through falsification, misrepresentation or fraud, or it does not conform to the shipping details provided in the movement documents, or it results in deliberate disposal, that is dumping of hazardous or other waste in contravention of the Basel Convention and general principles of international or domestic law. Treatment, storage and disposal facility for hazardous and other waste. The state government, occupier, operator of a facility or any association of occupiers shall be individually or jointly or severally responsible for identification of sites for establishing the facility for treatment, storage and disposal of hazardous and other waste in the state. The State Pollution Control Board shall monitor the setting up and operation of this facility regularly. Where an accident occurs during transportation or at the facility of the occupier, or operator of a facility handling hazardous or other waste, the occupier or the operator or the transporter shall immediately intimate this to the State Pollution Control Board through telephone, email, and subsequently send a report in Form 11. Now let us move on to the packaging, labeling and transport of hazardous and other waste. Any occupier of a place or operator of a facility handling hazardous and other waste shall ensure that the hazardous and other waste are packed in a suitable manner for safe handling, storage and transport as per the guidelines that are issued by the Central Pollution Control Board from time to time. The labels shall be of non-washable material, weatherproof and easily visible, and shall comply with other conditions mentioned in Form number 8. The transportation of hazardous and other waste shall be in accordance with the provisions of these rules and the rules made by the central government under the Motor Vehicles Act and the guidelines issued by the Central Pollution Control Board. The waste shall be accompanied by the movement documents in Form 10. The transported waste should be labelled properly and the transporter should be provided with the information about the measures that are to be undertaken in case of an emergency. Liability under the rules. The occupier, importer, exporter and operator of the disposal facility shall be liable for all damages that are caused to the environment or third party due to improper handling and management of hazardous and other waste. The occupier and the operator of disposal facility shall be liable to pay financial penalties as are levied for any violation of the provision under these rules by the State Pollution Control Board with the prior approval of the Central Pollution Control Board. Appeal. If any person is aggrieved by any order of suspension or cancellation or refusal or of authorization or its renewal passed by the State Pollution Control Board, then the person may prefer an appeal to the appellate authority, which is the Environment Secretary of the state. The appeal may be preferred in Form number 12. It has to be filed within a period of 30 days from the date on which the order is communicated to him. However, the appellate authority is also empowered to entertain the appeal after the expiry period of 30 days if it is satisfied that the appellant was prevented by sufficient cause from filing the appeal in time. Every appeal shall be disposed of within a period of 60 days from the date of its filing. Now, once we are well versed with the rules, let us move on to see what is the judicial attitude towards these rules. In a landmark case of Research Foundation for Science versus Union of India, the Supreme Court of India has made it clear that Union of India will ensure that the disposal of hazardous waste does not in any way lead to any environmental pollution. It also said that there was lack of concerted and consistent effort on the part of the ministry to show implementation of hazardous waste rule, and the Supreme Court has appointed a high-powered committee in this regard. In the case of Ganpati Metals versus MSTC Limited, the Supreme Court clarified that the rules relating to disposal of hazardous waste imposing statutory obligations shall be applicable to the parties concerned irrespective of the fact whether they have been referred to or not in the tender notification. To conclude, we can say that industries generate a lot of hazardous waste and other waste. Safe disposal of hazardous waste and other waste is required so that the coming generations as well as this generation do not face the problem of pollution. Plus, these wastes also create a lot of health problems. The workers who are working in the factories also are exposed to a number of risks. So, to conclude, we can say that the rules that have been framed by the government should be followed in spirit so that the hazardous waste and the other waste that is generated is disposed of in an environmentally sound manner. Thank you.